Hi, welcome back to the podcast, HOA Hell. I'm your host, Michael Kushner, and with me, as always, is Senior Associate from MBK Chapman, Sam Kill.
Good morning, Mike. How are you?
I'm fine, thanks. Before we get started, Sam, I wanted to just come to tell our listeners that, and I'll put this up somewhere, I just haven't figured out how I'm going to do this, but I was a guest on a podcast by an HOA-side law firm, one of the Big Ten that we frequently talk about. And this is actually, in my opinion, the best of all the HOA-side law firms in California. This one's the best. Mm-hmm. It's the best because I think they're the most ethical. I think they're very selective in the HOAs they accept as clients, and they do a great job educating their clients about the law. And that, for that reason, we have very few cases that involve HOAs represented by that law firm because it often doesn't even get that far. Mm-hmm. That tells me something good. So when they invited me onto their podcast, I went. I'll go ahead and name that firm. It's the Tinley Law Firm. Mm-hmm. So I'm going to, when they send me a copy of that, I'll find a way to post it somewhere. We just talked about the Davis-Stirling. We talked about the Davis-Stirling Act and the kind of cases that we take and kind of the things that we see from our perspective. Mm-hmm. And it was actually, I thought, a very good conversation. So look for that coming up. Today, Sam, we're going to talk about something that I recently wrote about in one of my fact sheets and that has been in the news a lot, especially in Orange County, California, because it involves a possibly very serious issue that arose in a South Orange County HOA in Ladera Ranch, the master community in Ladera Ranch. And many of you that are listening might be shaking your heads if you're aware of this. You've probably read about it in the newspaper or heard about it on the news. And that is the cluster of cancers that seem to have occurred in this, to children especially, right? Mm-hmm. In this very small community in South Orange County called Ladera Ranch. And many people have claimed that it is a result of the pesticides that are being sprayed in common areas by the HOA as part of routine maintenance. Yeah. And that it might be the amounts that are being sprayed or the frequency or something that's causing this cluster of cancers, a very rare cancer, I should say.
Rare childhood cancers, yeah.
Yes. Mm-hmm. And as a result of the tremendous amount of concern and worry on the part of many parents and homeowners in this community, which is a series of sub-HOAs as well. We're talking about the master HOA. The HOA actually put a freeze, I think, doing the right thing, even though there's no scientific study that shows a connection between that cancer and these pesticides yet. Mm-hmm. With recognition of that, just out of an abundance of concern, this HOA kind of listened to what all these homeowners were really saying, and it was a lot of interest in it, obviously, for parents. And they did put a
moratorium.
A moratorium. Thank you. That was the word I was looking for. Yeah. They put a moratorium on the use of this particular spraying. And that's the issue we want to talk about today. We're not going to talk about that case in particular as a case, because frankly, it will become a case just given the nature of California, and we're a lawsuit happy state, or a lot of America is, but California is not exempt from that. So we're not, our firm doesn't handle toxic tort cases. No. We're not interested in that. What we're going to talk about today is a tangential issue that stems from this situation. That is the extent of an HOA's power to decide on the vendors and or the chemicals or other things that people will be exposed to. And also the lapses, I think, in the Davis-Stirling Act that could easily be amended and should be. I will say one more thing before we get to the meat of the matter, and that is I am currently, and I'm not going to divulge anything yet because it's not done, but I am currently writing legislation, a very big piece of legislation that I'm going to be sending in to some legislators, looking for a sponsor to amend the Davis-Stirling Act to include an entirely new section to add some really stringent protections. If I get somebody willing to sponsor me on that, then I'll keep everybody posted. If I don't, I'm going to publish it anyway and urge everybody out there to contact their legislators and say, get us this law, because I think it's critical. But anyway, I might do it for this issue when I'm done with that. Once I get my feet wet in that, I might do it with this issue, what we're going to talk about today.
Mm-hmm.
So with that, Sam, let's talk about just, HOA boards have responsibility and they have power that relates to this issue. So tell me about that responsibility. Where does it come from and what's the power?
Well, the basic responsibility is to maintain, repair, and replace common area components in general. And what we're discussing here largely falls within the purview of Civil Code Section 4775, which affords and grants HOAs and their boards, by extension, the authority to maintain common areas. And that's what we're talking about. Responsibility. So landscaping, pesticide, pest treatment, all of that falls within, smack dab within that purview.
Not just mowing and trimming and fire abatement, in the as part of a landscaping plan. That any HOA that has common areas is going to have some green belt and might have hillsides and trees, and it just depends on the size of your HOA. But landscaping doesn't just mean making sure everything gets watered and having the water pipes there, and making sure the plants don't grow too big or the trees don't, get trimmed when they're going to fall down, or they get, it's not just that. It's also, what do we spray, if anything, to prevent pests? What do we, a lot of HOAs have rats, and there's rules about fruit trees and stuff like that, being too close to homes because the rats can travel by roof.
Exactly.
And those are all part of that maintenance power that you were just talking about. And that's exactly right. And the thing is, as part of that responsibility, they have the right not only to choose the landscaping vendors, but to choose the scope of what the landscaping vendors are going to do.
Exactly.
And so obviously that power exists. It's mandated to them in the Davis-Stirling Act, and it's a necessary power. You have to have that. And I think it should include everything we just talked about. From laying pipes to trimming trees to determining what kinds of trees are allowed to, if necessary, spray pesticides or other things to, inhibit pests. I understand that.
And the law grants them tremendous latitude and discretion when it comes to entering and engaging in these contracts to basically promulgate these practices. And just to be clear, and we can get into this if you'd like, it's not subject to a membership vote or a ballot, and the membership does not typically have a say in it. And that's
it would be unwieldy to do that. It would be impossible to run an HOA if you had to run the minutia of day-to-day operation decisions to the membership. That's ridiculous.
Agreed.
It just couldn't work. No organization can work that way. Too many chefs, too many cooks.
Slows down the process. Nothing gets done.
Pick your aphorism. But of course, you mentioned, just in passing, the contracts. And you're talking about the contract between the HOA and the landscaping vendor. Whatever landscaping company your HOA uses, that's a vendor. It seems to me, one of the things that I kind of wish was part of these contracts, and is not, maybe rarely, but it's certainly not frequently part of the contract, is the chemicals that are used by that company. I have seen many vendor contracts in my time, and most of the time, not always, but most of the time, it's not like a contract you enter into with your contractor to do something in your house where it lists the type of paint, right? It doesn't do that in a lot of these. I think it should.
It really should, because materials used is in my view, profoundly relevant in terms of, downstream, analysis, review, you discover things scientifically when there's a correlation.
There are a lot of potential effects that chemicals of any kind, whether it's, certain kinds of paint to certain kinds of perfume to certain kinds of whatever, that people can have strong reactions to in the form of allergies or in the form of ultra sensitivity, hypersensitivity, all the way to any, possible relationship between a chemical and a pre-existing genetic or environmental condition that would be triggered by. And from the worst case scenario, I think, something that is causing cancer to something that just causes discomfort or allergic reaction.
Respiratory conditions. I mean, that's
anything. Right. And so as a result, just because these chemicals, while they might be legal, of course they are, right? They might be legal, they might be deemed safe based on studies. Things do change, and people have children with not only adults but children especially, because their pulmonary systems are growing and they're a lot more sensitive than an adult. But there's often reactions to things that are perfectly safe and legal.
Yeah.
So I think, just as a matter of course, I think there should be a requirement that anytime a chemical known to the state of California to either be related to cancer in any form or that could cause reactions, allergic or otherwise, should be required to be listed if they're going to be used. They should be listed in a vendor contract.
Uh-huh.
It's not the case now, but I think it should be. I don't think that's too much to ask. What chemicals do you plan on using for that? What does your company typically use for pest abatement?
Yeah.
Well, we use a variety or a combination of the following. I don't think that's too hard to ask. It's certainly not going to be expensive to implement for anybody.
I mean, you know me. I absolutely agree, and I'm always in favor of transparency when it comes to these things. Record keeping, transparency, and being able to be an informed consumer, including the HOA itself as an entity, knowing what it's purchasing, right?
Agreed.
So I absolutely acknowledge that. To me, as you're talking about this, as we're discussing this issue, one of the foreseeable elements then is, what's the blowback effect once you have that transparency?
What do you mean?
I mean, one thought that goes through my mind is, you have possibly a heightened likelihood of, various folks, whether predisposed, immunocompromised, allergies, raising concerns and issues. And now you may have a kind of scattered pool of, and great variance among them potentially in terms of questioning what's being used, and then the pressure by extension on the board to then alter course or pivot to something different.
All right. So what you seem to be saying is, by divulging these things, you are going to create conflicts from people from different factions, possibly even to different chemicals, who are all going to be saying, "Oh, I have a hypersensitivity. My child has this and that," and it's going to create problems that don't currently exist.
Requests for accommodations, even in cases where you may not have correlation scientifically established. People.
That's a great point. I didn't think of that.
Yeah.
I didn't think of that, and I don't have an answer for it, to be honest with you.
Yeah.
Folks, if any of you has a comment to that, that would be the perfect thing to put into the YouTube comments. Send us your thoughts on that. Leave a comment. Send us your thoughts. I do respond to all comments. I would love to hear from you people on that, because I didn't consider that. And we didn't talk about this beforehand. We just broadly said, let's talk about the Ladera Ranch thing and its broader implications.
Well, even with Ladera Ranch, one thing that's implicated is it's currently being studied and investigated by the authorities.
Well, because of this issue.
Exactly.
But they've also come out and made it clear thus far there's no correlation. Okay. But at the same time, you have a cluster. You can't deny that. Given the rarity of this type of cancer that was reported in Ladera, and I don't remember the name of the cancer, to be honest, but given the rarity of that type of cancer and the fact that in this very, very small insular community, you have way more than you could expect to find percentage-wise anywhere in the population. Obviously, something is at issue. It can't be random, and people are pointing to the pesticides, but it might not be that. We don't know.
Right.
We think it's that.
The nationwide number was at 200 to 300 last time I looked at this up, and so that tells you that density within Ladera Ranch,
and that's out of over 300 million people in the U.S.
Right.
And then you have, I don't remember how many cases.
The number that comes to mind is 9. It could be north of that.
Yeah, I don't remember it. I wrote this thing a while ago. I only published it last week or earlier this week. I don't even remember when I published it, but I wrote it a while ago and I just didn't publish it yet because I have a bunch in queue. So let's go back to that issue you raised. You raised a very good issue. I don't have an answer for that right now. I'd probably just sit back and think. And just, sometimes I do that. You walk in my office and I'm staring into the ceiling. I'm thinking. Sometimes I just think before I write, or I think before I speak. I want to know, I want to think about permutations. Do you have any thoughts on your own? What's the solution to the problem you just raised other than let's keep it ignorant?
It's a tough one. It's a challenging one because the cost component to the association could be cost prohibitive if you create
not the disclosure part.
No,
having to deal with
various homeowners with their request to be either exempt or opting out.
How do you be exempt from something?
Or taking on, let's say, their own responsibility for their little area in front of them, in front of their curtilage or landscape area.
How do you exempt? So you have common area, you have pathways and parks and green belts and all this through the community. All right, you can't spray within 50 feet of that's not going to solve the problem if they walk around the neighborhood.
Agreed.
If their kids play in the grass or play in the park.
So what determines that is, I guess, the scope of that request. If someone is making a broader request as to all common areas and the green belts and playgrounds, it's
not reasonable.
Not reasonable.
And wait a minute, even if it's right in front of their house, I don't see that as a reasonable accommodation.
It's a tough one. It's a very tough one.
See, just gut reaction.
Yeah.
Remember,
It's
when somebody seeks an accommodation, it's not automatic that they get it. The accommodation has to be reasonable. It has to be the least intrusive. If there are other accommodations that could be made that resolve the same issue, but with less cost or intrusion to the HOA or to the rights of others, HOAs can choose that one. They don't have to choose the one you want. I don't see that as a reasonable accommodation. That's just my gut opinion. Again, I haven't sat back and thought about it, but that's my gut opinion.
No, same here. I would echo the same thing. However, the flip side, if we were to play devil's advocate for a quick second, is someone produces doctor's notes upon doctor's notes in terms of specifically isolating that as the underlying cause.
Then sell.
Exacerbates.
Then sell.
Then that may be the answer. That community is not for you.
And if there was a requirement that those chemicals be in the contract before you bought, you could ask for that document.
Right.
You could ask the seller, provide me with a copy of that.
That's a great point, because if you have that transparency, now you have disclosures, and perhaps new legislation or an amendment can add that into it.
No, I would add it to the existing statute of the Davis-Stirling Act about the I just did it. I don't remember if we did an episode, but I just did a fact sheet on the required transfer disclosure documents that are required in the Davis-Stirling Act. Just add that document.
Yeah. And I think that would also be aligned.
By the way, that document might actually already be included, not explicitly, but implicitly.
Oh, okay.
That's what I meant. Yeah.
But I mean, on balance, I believe espousing those types of policies and amendments and additions to kind of expand on a pre-existing statutory scheme, I think is protective of homeowners, consumers, enhances transparency.
And that's the thing.
And that's what
I think the benefits, the pros of the disclosure on the sheer numbers of homeowners that would be benefited from that will outweigh by a mile the issue, very real and probably probable issue that's going to happen based on what we know about homeowners. It's going to happen, but that's a minority number of people in the scheme of how many people it's probably going to you'll never hear from, but they're glad they have it.
Agreed. Yep.
In other words, you're right, that's going to happen, but I don't know if that changes my mind at all.
I would.
Nor do I think an HOA would be obligated to kowtow. But it is something, again, leave a comment if you have different thoughts on that. I think it's a great question, which leads kind of naturally into this next issue. We're talking about what we wish the Davis-Stirling Act required, because it doesn't require that. We just got finished saying that. I think it should require that. But now let's talk about and so that was, we wish the Davis-Stirling Act said that. Now let's talk about something we know the Davis-Stirling Act doesn't say. And let's talk about assuming that we don't, that nobody passes any kind of law that would have the Davis-Stirling Act require those chemicals to be named in the vendor contract. Let's talk about maybe another addition to the Davis-Stirling Act. Let's change what it currently says. Let's do another hypothetical. Say, okay, in the absence of that, let's do this one. And that is, we've talked in our podcast on probably at least 36 occasions in the over 200 episodes we've done, long and short. We've talked about Civil Code 5200. At SEC. That's the Civil Code section that allows homeowners access to review and copy association records and enhance association records, which is pretty broad. And the list of documents in particular, for example, on 5200A currently goes to 15. There are other documents located elsewhere in the Davis-Stirling Act that are also required, and they aren't found necessarily in 5200, but that's most of them. And then in my, we're not going to say anything, but in my new legislation, I've proposed it A16. This could be A17, or in the absence of my new one, this could be A16. Who knows? In other words, I think homeowners should be allowed to ask for a list of all the chemicals, pesticides, whatever, that are being used in the common areas of their community. So in the absence of that actually being in the vendor contract, maybe they should have access to the list of those so that the HOA would have an obligation to go to the vendor or vendors, say, what chemicals are you using in your day-to-day, functions that, in their scope of work.
Or if it's like a commonly known product, then folks can look it up independently and itemize.
No, but they have to list it, say, and then folks can look up. They don't have to list anything else. Just provide the names of the products. Let people do their own research. They can Google all that. But give me a name. Give me the names of all the chemicals that are used by our painters or our landscapers or whatever. I think the HOA should have to respond, and maybe that would require them. Maybe you give them 45 days for that one, because right now the 30-day rule is the maximum rule in 5200. Maybe you make that a 45-day rule.
Yeah.
Okay. But I kind of think that should be part of the Davis-Stirling Act. So if it's not affirmatively mandated that it be stated somewhere, because homeowners do have access already to the executed contracts between the HOA and the vendors. But if it's not in there, contract's not going to help.
Yeah.
If it's required to be in there, that solves this problem. If it's not required to be in there, maybe the solution is, okay, if a homeowner affirmatively requests a list of all chemicals used in day-to-day operations, and the HOA has to respond to that, then I'd be satisfied with that too.
Yeah.
How about you?
Agreed. No, that seems reasonable. I think on balance, that's outweighs the foreseeable.
Well, it might solve your problem.
Unintended consequences or undesirable outcomes. And then just like a quick note, it just occurred to me, as I know we emphasize the human part of it, but for people who are pet lovers, I know you are, anticipatorily being able to look into these things, right, to decide whether that community is for them or not. I mean, I think that's another facet. That's
well, the only difference is a 5200 demand is only allowed to be brought in by a member.
Agreed.
So if a homeowner,
this goes to the disclosures, I guess.
Right.
Yeah.
So it would have to be something that a prospective buyer could ask for to be included in the disclosures as well.
Right.
Okay, because you always have to remember that 5200 only exists for members.
Right.
Not tenants.
Yeah.
Not residents.
Yeah.
Members.
This would be more the escrow disclosures, but it's a separate issue. You're
Agreed.
Right. Yeah.
Agreed.
Yeah.
And by the way, there are lots of disclosures when anybody that knows that's sold a house. You've got the Megan's Law disclosures. You've got lead paint disclosure. You've got asbestos, lead paint. You got all these mandatory disclosures. Let's just make this one too.
Yeah.
Why is asbestos so special? Asbestos. I think asbestos. If I had to choose between that very rare child cancer or asbestos, a mere, infrequent exposure to asbestos, I think I might prefer the asbestos, to be honest, than the cancer. So I think it's equally important.
Yeah, well, I think with asbestos, it was just the sheer volume of it nationwide that kind of,
because it was used up until our 70s or the 60s.
Yeah, it was just much more widespread. Yeah.
Well, it was in pretty much everything, because it's actually a miracle substance.
Yeah.
Other than once it's broken up or in the air, then it's not good. Right. But when it's not, it's actually pretty cool substance. It's pretty useful.
I guess. Yeah.
It's fire retardant nature and all that
definitely.
stuff.
I mean, there's a reason for their use. Yeah.
Yeah. So, yeah, and its insulating abilities. I mean, it's pretty spectacular.
So you're a fan of asbestos?
Well, I'm a fan of it when it's not it's not aerolized or aerosolized, whatever the word is. I don't know the word.
Sure.
I'm not a science guy. Aerolized or aerosolized. When it's not that, it's fine. It's just when it becomes a problem, like in the brake pads.
Disrupted.
That's a problem.
Yeah. True.
Yeah. Yeah. What else? Tell me. What else is kind of tangential to this Ladera thing?
Well, the thoughts that go through my head, it's a bit unrelated to the podcast we're focusing this on, is disclosures for people who want to sell. Things
you
like...
mean the people in Ladera?
Ladera, for instance,
now they have to.
Right.
Assuming that you're a buyer that hasn't looked at the news or seen it, right?
Well, the counter to that is, okay, well, it's publicly known, open
unless you're an out-of-state buyer coming in from, like, you're moving from Iowa or something.
And no correlation has been established. So then really, what are you disclosing, right?
That's
that would be the counter.
Is this required? I would say,
yeah.
Okay, if I'm a seller, if I live in Ladera, and I did, by the way, I lived in Ladera from 2002 to like 2004 or 5, something like that, okay? If I'm a Ladera seller, I'm going to disclose this out of an abundance of caution, because I don't want to be on the receiving end of a failure to disclose lawsuit.
Agreed.
So
and not to take this too far, but maybe perhaps a prospective buyer will absolutely assume the risk, especially those who may not have children or may not really see this as, let's say, an imminent issue to them. And
I'm old enough now. By the time I get this, I'll be dead, kind of thing.
Or investors, right? Investors who purchase for their own to rent it out, for instance. That could be a thing. But then again, they have their own set of concerns they need to worry about. So that's one.
Is this, do you think that this would be something you'd have to disclose? Not just that you'll choose to because you want to manage expectations and manage your risk. Is this something you think would fall under required disclosure?
At this time?
Yeah.
At the moment?
Right now?
I don't have an unequivocal or affirmative answer for you, but I'm inclined to lean in the direction of yes. I would absolutely do it, if nothing else, by virtue of it being under formal investigation
and scrutiny. I agree.
So while there's no pending lawsuit, as I understand it yet, unless there is, it's a quickly developing and evolving situation. Right. So we don't have our pulse on a minute by minute.
I agree with you. But, I think I can't give you a specific reason why I'm saying this because, I can't say under this statute. It's actually I think it's covered. I think it's enough of a potentially known defect,
right,
that I would do it anyway. And if I were counseling a client, I would say, let's disclose this. If I'm an agent, I'm not a real estate agent, but if I was, I would urge my client, the seller, to disclose it out of an abundance of caution. Given the speed at which this is progressing and nobody knows where it's going to go and what the results are going to be. So I agree absolutely, because let's say it was litigation, it would be mandatory at that point. So what's the difference?
2 quick comments. This is also a situation where, to the best of my knowledge, you don't have constructive notice, meaning this is not a publicly recorded document, something that runs with your title.
Yeah, you could be coming from out of state where it's not on the news.
However, within the association, the current membership and the seller, in a hypothetical context, would be on notice of the existence of this issue 100%. By virtue of the notices that went out within the association.
And posted, yeah.
And so guess what? You ought to disclose that.
I don't think that you could be an owner in Ladera Ranch and claim with a straight face that you're not aware of this issue.
Agreed.
I'm not saying it's not possible, but I would be surprised unless, and by the way, if you could prove that you weren't aware, like I've been in a nursing home, for blah, 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 or my dad's been in a nursing home and I've got power of attorney and I don't know what's going on there. He's the one that lives there. I'm selling it for him. Whatever. I could see that, and that would be admissible and that would get you out of the trouble. But I actually agree with you on everything you said. I think it's probably mandatory, but I can't tell you why I'm saying that, but I'm saying probably because I can't unequivocally give you the legal reason why. I just think it is. And it certainly would be once it crossed the line into an active lawsuit. And I don't see a difference, to be honest, because I think it's imminent,
right?
Just because of the nature of our state. So I just think it's going to happen. And of course, if I lived there and I had kids that were young, and mine's grown, but I had kids that were young, I would be very concerned. You've got small kids.
Yeah. I
would be concerned as a parent. I wouldn't panic over it, but I'm not going to ignore the statistics on this and the fact that if you're correct on the 300 nationwide out of a population of over 300 million, and then you look at the number here, that's a staggeringly large statistic for such a small geographic area. Mm-hmm. There has to be something there. And this seems to be the best candidate. And I think it came out that Ladera actually sprayed more volume of it than is normally done. And that might be the reason. And that's probably what's being studied.
Yeah.
So who knows what the future holds on that.
Right.
You have anything you want to add to this?
Just one nugget. I was debating on whether to mention this, but I saw something last evening. Mm-hmm. Capistrano Unified School District has also put a moratorium on their spraying.
Because of this?
Because of just pending the outcome of this matter being investigated by the agency.
Is it the same chemical?
Same concern.
Oh. Are there any?
The chemical in itself, I don't believe has been fully identified or there's a nexus.
Well, so they're just stopping of spraying.
They're stopping out of an abundance of caution.
See, that's a little weird to me. I think it should, it should be apples and apples, but.
And if I'm not mistaken, there was an incident with one of their teenage students who unfortunately succumbed to some of the same or the similar condition. That person, I believe, has passed. And she was a kid? And she was a student. She was a student at one of their schools. So hence that led to a bit of an uproar. Was this a
resident of Ladera by any chance?
I don't know. I don't have an answer there.
Because Capistrano Unified is, I don't know if Ladera is in Capistrano Unified. But if it's not, it's right next door.
I didn't check for that specifically, but
I didn't go to school in Orange County. I went to school in Long Beach. So.
But just to kind of give you a sense in terms of the quickly developing situation, and then it's apparently that concern is spreading.
That's a good point. Yeah. I wouldn't be surprised if it was the same chemical then, because it seems to me to be a little bit extreme to say, okay, no pesticides, because that's overboard. I don't think there's a reason to panic. But if it's the same chemical, I could understand why a school district might make that decision. Right. And poor girl, you know.
Absolutely. Yeah. Unfortunately, we're not privy to the details in terms of the chemical specifically or the specific pesticides, but it may be there may be a nexus there where they have looked into it.
I didn't see that. Yeah. Okay, that's a great point. I guess the bottom line, folks, is real simple. You know, incidents like what's happening in Ladera Ranch and maybe what's happened in the Capistrano Unified make people like us as professionals who represent and counsel homeowners that live in HOAs. It brings to the foreground issues of governance that kind of touch on these big events. And directly touching on this Ladera Ranch thing and this Capistrano Unified thing is the people's exposure to certain chemicals and substances that HOAs in particular have an absolute right to have vendors use in their communities, and they do that without the need to get any member support. And what does that mean in terms of responsibility to homeowners, and should there be any additional requirements in the law to help people make decisions for themselves as to how much they want to be exposed to those chemicals? And so, that kind of leads to that discussion as to whether or not some of these disclosures should be part of our Davis-Stirling Act or not. And at the very least, at least that discussion and the need for transparency and the importance of transparency. If you like this episode, please hit the like button. And if you haven't already done so, please subscribe to our channel, HOA Help. If you have any questions, leave a comment. As always, have a wonderful day.